afternoon and welcome to the Court of Appeals. We'll take just a few moments before we get started and talk about our procedure and take care of a few housekeeping details. First of all, I know we've got experienced practitioners, but I always feel the need to go over the ground rules just a little bit. Each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, you may reserve up to 5 minutes of rebuttal time. The proper way to do that is after coming to the podium and after you've introduced yourself to request that time from the court. Obviously, the appellee gets no rebuttal time. We have a lighting mechanism on the court that we believe is helpful. Once you begin your argument, a green light will come on. A green light will stay on until your time begins to run out. Then a yellow light will come on. And then the red light comes on. And when the red light comes on, we ask that you please respect those time constraints. Probably one of the most important things for everybody to understand is this. These arguments are being live streamed. So please think about what you're saying, because once you've said it, it's out there for everybody to hear, and we have no control over that. So just think about that as you make your argument. Your panel this afternoon will consist of Judge Kenny Armstrong from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before we call the first case?
No, Your Honor.
All right, you may call the first case, please.
Caroline Brown Smithwick versus Fred Barksdale Smithwick IV.
Okay, here from the appellee, or excuse me, appellant. I need to get my nomenclature right.
Judge, you started by throwing me for a loop.
Well, I tried.
It's all good. If the court please, I'm Mitch Moskovitz, and I, along with Kirkland Bible, are here on behalf of the appellant, Caroline Brown Smithwick, and I would ask the court respectfully if I could reserve 3 minutes for rebuttal,
3 minutes.
please.
All
Thank
right,
you,
sir. You may proceed.
Thank you, Your Honor. If the court please, I'll be brief insofar as the procedural background, but I think it's a little bit unusual. And the one focus or focal point of my argument is this, is one who now has been here a number of times, as Your Honor pointed out, that both Mr. Caparella and myself certainly have, and Ms. Bible's well on her way, and certainly Mr. Smith, who's not present today, but was certainly involved in the case. It is, I submit to the court, unusual as a matter of law that when you have children who are doing well and the parents acknowledge that the other parent, by way of example, in this instance, the father, clearly has identified and recognized that the mother is a good parent, that there be a significant change in the parenting schedule or the designation of the primary residential parent. This case actually involved two separate, different judges. The court will recall that in March of 2021, the parties agreed to a parenting plan. The mother was designated as the primary parent. She had some 237 days. And the father was the alternate parent, for lack of a more appropriate term, but was not the primary parent. He had some roughly 138 days of parenting time. Some 1 year, if not a few days shy of a year, the father filed a petition to modify, all while Judge Weiss was still on the bench. And we had a trial before Judge Weiss in July of 2022, and ultimately an order was entered on or about September the 8th of 2022. The primary issue in that trial was father wanted equal time, father wanted a joint designation of both parents being primary parents, and there was a dispute about where two of the children would continue to attend school. They were at Briarcrest. The mother desired that they change to Lakeland. The father desired that they continue to be at Briarcrest. And both, frankly, were, for lack of a more articulate or appropriate term, lectured by then Judge Weiss about decision-making and who had the right to sign up, and they both had signed up at the schools. Ultimately, Judge Weiss agreed with the mother and said the children, notably Eli and Ellie, would continue, or strike that, would go to Lakeland. And there was a stipulation entered, in fact, that both parents acknowledged Briarcrest and Lakeland were good schools. Judge Weiss denied father's petition to modify, left the schedule intact, and did fine mother in civil contempt for not communicating regarding decision-making and ordered her to pay $5,000 in fees and ordered a status conference. Soon after the trial, about a month after, Judge Weiss, who ran for election, didn't win, and Judge Dandridge was elected. And father filed a petition to reconsider. And if the court please, he then filed on December the 16th of 2022 a petition to cite mother in contempt, and he wanted decision-making authority. And then in April of 23, he filed an amended petition to cite mother in civil contempt. We had a trial before Judge Dandridge in, if the court please, June and August, some 4 days of 2023. And if the court please, ultimately, Judge Dandridge entered findings of fact in an order that I'll touch upon, where she modified or changed the designation of who the primary parent was, despite the fact that father asked for joint, she designated father. She ordered equal parenting time. She ordered mother to pay some approximately $88,000 in attorney's fees. She ordered mother to pay some approximate $1,000 in retroactive support for a period of time that the schedule remained as it was, not equal, but the 237 and 138. And in addition to that, if the court please, she made certain other findings, including mother being responsible, although it wasn't pled, and although there are a lack or scarcity of findings in the record as to why, to pay for the third of the three children, Ethan. And if the court please, the children now were approximately 12, 11, and 8. They were young. And Ethan, who had some learning issues, was at Bodine, and she ordered mother to pay all of the tuition, despite making any findings about a deviation from the guidelines. So suffice to say, it was an unusual procedural background, and certainly here on behalf of the appellant, based on the record and the application of the law, particularly when it was undisputed that the mother was a good mother, the children were doing well, and there was no impact that any decision-making of mother or father had a material impact or certainly a negative impact to any of the children. So it is a rarity where this lawyer stands before you in a parenting appeal and says, we've got the parent who's prosecuting the case or the moving party saying, mom's a good parent, I trust her insofar as her decision-making, and the children are doing well, and we should have a change in the schedule or a change in the designation, and a requirement that she pay retroactive support, some $88,000 to $90,000 in fees, and retroactive child support. So certainly in the limited time that I have, as I've often said, the briefing, which I know the court has reviewed and will review, certainly speaks volumes about the findings or the lack thereof that would support what Judge Dandridge did. The court is well aware in your years on this bench and perhaps others that the bitterness divorce brings, unfortunately, all too often. In this case, unfortunately, it was no different. The court's read, I think it was Trial Exhibit 25, where the father acknowledged or suggested to the mother, and I quote, that Judge Weiss isn't the judge anymore. It's a brand new judge, and this one's not your lawyer's pocket. So it was filled with some degree of bitterness, and I certainly acknowledge that as the lawyer who's probably the only lawyer in this case who's been involved since day one, meaning the divorce being filed and the underlying divorce and all the post-divorce litigation. But the court may say, well, Mr. Moskowitz, did you cite in the record where these children were doing well? And did the father say that and the mother say that? And if the court please, in this record, interestingly, we certainly did. And if the court please, there's no dispute despite the changes that the court made, that both parents testified not only in front of Judge Weiss, but also in front of Judge Dandridge, that the children are doing well. The father says the children have adapted well. They're very good. And I'm reading from volume 10 of the record at pages 126 and 127. I mean, case in point, they had to change schools. They were able to do that, and Eli's done well. Eli doesn't make grades, but she has good conduct and things like that. And Ethan's progressing, so my children are very strong. But it doesn't end there. As I've said, the father is acknowledged, and it's at trial, volume 11, pages 284, 341, and 342. Caroline, the mother, is a good mother. There's no dispute about that. I value her opinion because she's a good mom. If the court please, there was some suggestion about the mother had remarried. But in this record, if Your Honor please, the father's acknowledged that her remarriage had absolutely nothing to do with why he filed any petition. In fact, the children got along well by the father's own acknowledgement with their stepfather. And the proof in this record is the children had a good relationship with him. And yet, despite that, there's the findings from Judge Dandridge where there was a change in circumstance. And let me attempt in the few minutes that I have to address that. Here, if the court please, there was an abuse of discretion, we submit. The court used the wrong standard, applied the wrong statute insofar as, and we've detailed all of this in our briefing. And if the court please, there's nothing in this record to submit or suggest that any material change, should one have existed, whether, if the court please, Section 366101A2B or 366101A2C is to apply. And frankly, in this case, despite modifying and changing the primary residential parent or custody, the court utilized 366101A2C when she ultimately should have utilized 366101A2B. But under any circumstance in this record, there's nothing to support that any conduct of the mother had any material effect, no negative effect, and if anything, a positive effect on the children. Case in point, school we've addressed, and it's set forth in our briefing. There was a second issue about health insurance and health insurance cards. In this record, mother testified that she notified father that there was a change. On December the 15th, if the court please, December the 15th of 2022, father sent mother a note about health insurance cards. There had been nothing from the time that mother notified until the time father sent that note in this record, other than that request. But on the following date, he filed an amended petition or a petition to cite mother in contempt and change the decision-making. And if the court please, the insurance cost them less. The kids saw the same physicians. There's nothing in the record that had any impact whatsoever. And then there was that second petition, again, in April of 2023, that father filed. And in that petition, the focus, in the short time I have, was, if the court please, an allergy shot. Yet father acknowledged that he knew for months that she had taken the child off his allergy shots. And in this instance, it had no material impact. And there's nothing in the record to support it. But nonetheless, the court, despite the fact that there's nothing to submit or suggest anywhere in this record or in the briefing that any of the decisions that mother has had, where she arguably could have done a better job of communicating. But when kids are doing well and assume the court were to find that she should have done a better job in communicating, the father still said she's a good mother and I trust her insofar as her opinions. And here we had children, 3, who were prospering with the change. I know my time is up, and I listen, Judge Stafford. I'll be seated and wait for my rebuttal to finish. What, if any, other arguments? Thank you.
Thank you.
Good afternoon. Donald Caparella of the Nashville Bar. I represent Fred Smithwick in this case along with Joe Smith. Your Honor, the statute about material changes in circumstances that we believe applies in this case says that a significant change in circumstances can arise from failure to adhere to a parenting plan. That's one of the material changes in circumstances. Here we have two different judges, Judge Weiss and Judge Dandridge, who together found 11 different times that the mother violated the parenting plan. She took children off medication a couple of times. One time she put one of the children on ADHD medication, went to the doctor, none of it consulting with the father. And there is a very clear, unambiguous order that requires her to consult with the father. And I submit, Your Honor, that a failure to adhere to a parenting plan, and particularly the requirement to, in good faith, consult, when you have 11 different violations found by different judges, it undermines the father's ability to fully participate in these children's lives because he's not being consulted over a period of time. And most of these violations by the mother occurred after the petition was filed and while they were in litigation, when mother should have been aware that there was a judge watching everything she was doing, and she did it anyway. So the court found that, along with several other things, amounted to material change in circumstances, even though counsel said on repeated occasions, there's nothing in the record to support what the trial court did. Well, there's a 51-page findings of fact and conclusions of law that the judge entered that lays out in great detail the issues and what was found.
Was the judge the author of those 51 pages?
Yes. It's not identical, but more importantly, that issue's not been raised on appeal.
Well, we have Trezon that says that if you raise it anywhere, you don't have to use it as a stated issue. If you raise it in your brief, it's an issue that we can consider.
It's raised in a footnote. But still, yes, if you read, well, first of all, the court ruled that the findings of fact and conclusions of law are not even supposed to be in the record, but they are inappropriately. The clerk sent it up anyway. But secondly, if you look at them, they are similar, but they're not the same.
I missed that last statement.
There was a fight in the trial court about what should go up to the Court of Appeals. And the trial court said that the proposed findings, fact, and conclusions of law should not go up. And that's an order, but they went up anyway. So they're in your record, but they, according to the trial court, shouldn't be. But we submit that.
Let me ask you, if we didn't have that, and all we had was, hold on, I forget how she designated it, a final order. Is there enough in that final order for us as an appellate court to conduct a review of what occurred?
Well, without the findings of fact and conclusions of law, the answer to that is clearly no. She doesn't make any of the findings, while in the finding of facts and conclusions of law, she goes through each factor and analyzes it very carefully. So I would submit that she signed it, she adopted it, and it is not identical to what was filed by Mr. Smith.
And what respect is it different from what Mr. Smith filed?
It's got some of her own thoughts, some unchanges. It's got some of her own typos. It's not identical. It's not, I don't think that's an issue properly before this court, but I submit that it is hers. It is the trial judge's.
Well, do we have in the record a copy of what Mr. Smith filed?
I believe it was submitted inappropriately by the clerks, but yes, I do believe it's up there.
All right, and so if we read that and compare it with what was incorporated, you're telling me they're going to be different?
I believe they're different. Now, I didn't think this was even an issue before you, so I didn't show up with a highlighted one, but I looked at it briefly, and I think it's not identical. There are differences.
All right, go right ahead.
But you can look at them and decide for yourself whether they are.
Okay.
But I would submit it's not an issue before the court. So now, in addition to the finding by both trial judges that there were 11 different violations of the parenting plan, the court also found some additional things that amount to, under the statute, material changes in circumstances. One is mother's remarriage and living in a new blended family situation with the new stepfather, and not all material changes have to be negative. They just simply are changes in the lives of the children. They are now going to a new school. When father lost in front of Judge Weiss which school they were supposed to go to, father said, well, I'm not going to, continue to fight that fight, and if I win that with Judge Dandridge, rip them out of the school. So he let that go, but he still said it was a violation of the parenting plan for her to just enroll them in the public school. So that meant that they were now, with the schools, even closer together, making it easier for the father to have a 50-50 parenting situation. The trial court also found that father was correct when he said that stepfather had a persistent acrimonious relationship with him.
And where in the record will we find proof of that, other than this one comment about the iPad? What other conduct supports this finding or conclusion by the trial court that there's a persistent conduct on the part of the stepfather to affect the relationship between the children and their biological father?
That was the only incident that was testified about. Father did say, without giving any more details, that there was a persistent acrimonious relationship and that he was rude to him, but he didn't provide any other specific incidents.
So all we have is conclusions, then. We don't have anything in the record that will support that finding of persistent conduct on the part of the stepfather.
You have father's testimony, and you have that particularly nasty interaction. You also have the mother saying she agrees with him that father is that way. So we have her facilitating. I would submit that there is enough in the record to support that finding.
Okay.
Let me change gears on you just a minute, because I had a note that I wanted to specifically ask about. Apparently, Judge Weiss entered an order on September 8th, 2022,
Yes.
where he denied father's petition to modify. Then there was an election, and my notes say that on October 25, 2022, father filed a motion to reconsider.
Yes.
Is that accurate?
I believe it's accurate, but his motion was a motion under Rule 54.02. It was called a motion to reconsider. It was a motion under Rule 54.02 because there was no final order, because the court, when he issued his order on September 8th, said, we're going to have another hearing in December
Okay.
to determine what school that the children go to. But the other thing that Judge Weiss said I think is really pertinent, he says, if mother continues to act unilaterally and violate the parenting plan, I will consider changing the parenting plan. And that's exactly what happened in this case, is that mother continued to violate the parenting plan.
So the September 8th order was just an interlocutory order.
Correct. By its own terms, it was interlocutory because he ordered further things to happen in that case.
So I'm assuming then, well, I don't know what I'm assuming, as a matter of fact, because I would suspect that the October 25 motion would address things that happened subsequent to the September 8th order, instead of just revisiting it.
Well, under Rule 63, the court certifies that she's familiar with the record, and Judge Dandridge has the ability to reconsider the issue of whether or not there have been a material change in circumstances, and she did that. Now, adding to the 8 findings of not following the parenting plan that Judge Weiss found, which some of them were pretty serious, she found 3 more and held the mother in civil contempt. So, and there, again, there's not even a footnote, Your Honor, about that issue. There's no challenge on the record that anything, that Judge Dandridge being involved in this case.
I understand what you're saying, but if something's obvious to us, then it's something that we need to raise and have explained.
Sure. Well, and did I answer your question about there not being there's not a final order?
You answered it as much as you can at this juncture.
Okay. Well, I don't believe there was any issue about that because the order said we must do some additional things, and he didn't release jurisdiction. So
All I'm doing is looking at my notes, so I'm just trying to
Sure.
flesh it out.
And then the last issue that was raised, because there were 2 or 3 civil contempt motions filed had to do with the trial court finding that mother was impaired at a school event. And there's some dispute between the mother and the father as to why she was impaired. She claims it was because she took two different medications that did not go well together, although she admitted that both sets of medications said you can't drive when you're on them, and yet she drove one of the stepchildren that day. And the court ordered a test, and the test showed that over the past 90 days, she had gone above the level for heavy drinking on that, and the court found that was an additional finding supporting her finding that, the trial judge's finding that the parenting plan should change and that father should be the primary decision maker for all these things. So all these findings together, we submit, support what the trial court did, but more importantly, it doesn't show that there was any abuse of discretion. So that, I think, is something that they failed to establish. Now, all the civil contempt review of all the civil contempt findings is also done on an abuse of discretion standard, and we submit that they have not met those as well. So there's an argument about the retroactive child support that I just want to briefly address. They argue that the proper date to use for the retroactive child support is not the date of the filing, but there's a case right on point. It's 2001 Westlaw 103-5174, Smith versus Smith, that says that when you are doing retroactive child support, you do go back to the date of the petition. So we submit that that is a good reason for you to affirm that as well. We also believe that the challenge to attorney's fees is based upon the finding that the civil contempts were not properly found. There is no challenge to the reasonableness of those fees. There was no, the affidavits were submitted and nobody was put on the stand to challenge that. But the court, if you find that the civil contempts were properly in place, we'd submit that you should affirm the attorney's fees.
Let me ask you on the retroactive child support, that changed because of what? Is it because of the change in income? Because the visitation didn't change. I mean, the days were still the days they were. Explain to me how we get retroactive child support in this case.
Well, just the case I just cited, you say that you go back to the day of the petition.
Different set of facts from our case.
Okay.
I'm just trying to figure out, in our case, how do we get retroactive child support? The visitation, the number of days didn't change at the time of the filing of the petition. Did the income change? Is that what we're basing it on?
The income did not change, no.
Well, if the income didn't change and the number of days of visitation didn't change, how do you get retroactive child support?
Well, if the Smith versus Smith case is not applicable, then I don't really have a good response to your question, Your Honor.
Okay, all right.
So in conclusion, we submit that the abuse of discretion standard of review has not been met, and that you should affirm the ruling in this case in all respects and consider awarding attorney's fees on appeal, because we're appealing parenting plans and things like that, and under 365103C, that allows you to, in your discretion, to award attorney's fees. Plus, since this involves civil contempt appeals, you can also award appellate attorney's fees.
Let me ask you about the civil contempt. One of the contempts was based on the health insurance. How is that a basis for finding of civil contempt? That she didn't consult with the father about the health insurance? Because as I read the major decisions, the health insurance was not one of the things that she had to consult about.
It's expressly in the parenting plan, Your Honor, that when health insurance...
Can you read that part to me that
yes.
says that?
If I go to my...
Sure.
Just read that. I just read it. I'm going to go just by memory. The she had an obligation to tell the father when health insurance changed or report on its status on an annual basis. And it changed during that period of time, and she did not consult with him, and she admits she didn't consult with him at all about changing it to her stepfather's insurance. So
If you read the parenting plan closely, there is no requirement that she consult with him about health insurance. It instructs her to advise him if there is a change, but it doesn't say that she has to advise him at the time of the change. It says that she can do it either at the time of change or annually. And I think they're arguing that she did it annually.
well, I believe that she had an obligation to consult with him on that. And more,
You didn't find that in the parenting plan.
I don't have it in front of me because I just don't have that. It's a big record, and I just don't have it in front of me, and I'm
Well,
sorry.
you can find it in the parenting plan, and there's a provision about the things that she has to consult with him on, and health insurance is not one of them. It's medical care, extracurricular activities, a couple other things, but it doesn't say anything about health insurance, as I recall.
Well, she certainly had an obligation to provide the insurance cards, and she didn't do that in a timely fashion until she was subpoenaed. So we believe at least that one would definitely apply, and certainly taking the child off the allergy medication without any consultation with the father or even with the doctor.
So even though taking the child off the allergy shot was in the best interest of the child, the mother should be held in contempt for that? You read the doctor's deposition. You know what he said.
Yes.
That was the right thing for her to do.
Well, there is still the problem of consulting. So the trial court, they would have to show it as abuse of discretion. And obviously, Your Honor, if you want to read it the way you do, it's your call. But we submit that it's appropriate to affirm the trial court on the civil contempt.
Okay, all right.
Thank you.
Thank you.
If the court please, in the few remaining moments or minutes that I have, I'm going to attempt to address each of the questions posed to Mr. Caparella. First, but for father objecting to this court seeing and the court agreeing with father, his proposed findings of fact versus the court's findings of fact, which we did cite in a footnote on page 12 of our briefing that the court has clearly read, I would submit to the court they're virtually verbatim, and it was an adoption of the father's findings of fact. Second, insofar as the question that was posed about health insurance, she did consult, and it was a non-issue until December the 16th of 2022. It was a non-issue, and nothing in the record supports it had any impact whatsoever on the children. In fact, it benefited the father. And as to this issue about allergy shots, the court has clearly read the doctor's deposition, and I submit to the court that the father knew about that for months. By his own acknowledgement, we cited this in the record. In September or October of 2022, he testified that he knew about it and it was a non-issue. And so what's transpired here, frankly, is a number of non-issues have created a significant result negatively impacting the children when these courts, Your Honors, and our courts for years have held that courts favor existing parenting and custody arrangements. And there's a reason the statutes are drafted as they are about material or substantial and affecting in best interest. And when you have children who are prospering and doing well, the changes that affected anyone, and we've cited this in our briefing, where the father never liked, quite frankly, and was never pleased with the parenting schedule. The father, not the children. And we've cited in our briefing when he answered my question before Judge Dandridge about, and I'm paraphrasing, but it's in the briefing, why the changes. And then he says, not I said, not the mother said, to me, to me, to me. Well, me's not the children. Me's a parent. and he agreed to a schedule. And I would ask most respectfully, the three of you, to do exactly what our appellate courts have done for years, and that is favor existing custody arrangements, particularly when they're working. And there's no basis in the law to require her to pay retroactive support. There's no basis in the law to require her to pay $90,000. There's no basis in the law to modify the existing arrangement. There's no basis in the law to require her to pay all the tuition for a child they had agreed would continue with special learning circumstances at Bodine. And this record is replete with abuse of discretion,
Let
frankly.
me ask you, Mr.
Of course.
Markovitz,
Yes, sir.
after you've shown a material change in circumstances,
Yes, sir.
do you have to show anything else to support a modification as occurred in this case?
As to custody, yes. As to parenting or schedule, I believe yes, insofar as at least best interest. But I would submit to the court that, one, the wrong standard was applied that we've detailed. And so the simple answer is it depends on which standard, but I believe under both standards, yes. And what you don't change is when children, and I say respectfully, trial courts, should not change based on the law in our state. When children are doing well, by all parents' acknowledgement, we don't materially impact and change primary parent. We don't change schedules. And I'm fully familiar with what the statute says, and I know my time is over, and I want to be mindful of what Judge Stafford said, but I think you deserve a response if the court will allow me, Judge Armstrong. But the answer is yes. One, there aren't material changes in this record. And two, they certainly don't in any way impact these children. In fact, if they impact them at all, it's to the positive. And that's replete within or full within the record that you have before you. If I may, with the court's
I
blessing.
think you've responded.
I'll sit down. Thank you. And
Thank you.
thank you for the time and attention.
Thank you, counsel. We appreciate your argument. We'll take this matter under advisement, and we will try to get you an opinion at the earliest possible date. Thank you.
Thank you.
You may be excused.